Hello, I'm Claudia Rickert Isom. I'm the 1999-2000 chair of the Florida Bar Standing Committee on Professionalism. And we're here today with the Honorable John M. Scheb, who's a senior judge with the 2nd District Court of Appeal and a current distinguished professorial lecturer on the faculty of the Stetson University College of Law. Judge Scheb served for 17 years on the 2nd District Court of Appeal before he took senior status. He was appointed to his position on the 2nd District Court of Appeal by then-Governor Reuben O.D. Askew. Prior to that, he practiced law for 23 years in Sarasota. Am I correct? Okay. And now serves, as I said, on the faculty at Stetson University College of Law. We're meeting today at the Attorney's Study in the Stetson University College of Law Library. Welcome, Judge Scheb, and thank you for taking time out of your schedule to meet with us today. Judge Scheb, could you please share with us what your family and college background was before entering law school?
Well, to start out, I was born in Orlando, Florida in 1926. In 1933, right in the depths of the Depression, my mother and father, my 3 older brothers and older sister, and I all moved to Sarasota, where my father and my older brothers found some employment opportunities. I graduated from Sarasota High School in 1944 and immediately entered the then U.S. Army Air Corps. I was trained to be an aerial gunner. Fortunately, the Second World War was over before I had to see any action in that regard. On discharge from the service in 1946, I entered college.
And where did you go to law school?
I went to law school at the University of Florida in Gainesville and graduated in September 1950.
What or who motivated you to go to law school?
I suppose you could go back to a lot of things. When I was in high school, I developed quite an interest in civics and history, government. I had some very good teachers in those fields, and somehow I seem to have been elected to the student council rather consistently, and worked on the high school's parliamentary procedure team, so I became rather interested in law. Still, when I started college, I thought I would probably major in some form of business administration. My brother-in-law, who was 7 or 8 years older than I, and who had begun to make his achievements in life without the benefit of a formal education, because he grew up pretty much in the Depression. He knew the value of education, and he thought that I would make a good lawyer. And so we talked about it quite a bit, and I decided that I would try to go to law school. I was accepted, and I liked law school, and I became increasingly interested as the courses went on.
Were both of your parents college graduates?
They were not. I don't believe anyone in my family had the opportunity to go to high school. Excuse me. I don't believe anyone in my family had the opportunity to go beyond high school.
So not only were you one of the first in the family, I guess, to go to college, going on to law school was quite a reach.
Yes, it was, and I was very proud of it, and I think my family was proud of me. However, I regret the fact that my older brothers and sister grew up during very difficult years in our country when very few people went on past high school.
Where and when, I guess, did you begin practicing law?
When I graduated from the University of Florida, I returned home to Sarasota and I began practicing as a solo practitioner. That's a type of practice I don't necessarily recommend to young lawyers today, but times were considerably different. The older lawyers in the community sort of took you under their wing, so to speak, and they would send you cases and maybe ask you to help them on something where you would receive a modest fee. This was a time when mentoring was more common, far more common than what we know of it today in the legal profession.
When did you start practicing? What was the year?
In 1950.
So,
Excuse me. To clear my throat. All right, I'm ready.
isn't the following year when the Florida Bar became the organization that it is now?
It was actually organized in 1949, and 1950 was really the first full year of organization, as I recall, when we became what it was known as an integrated bar, that is, one which you had to belong to in order to practice law. It was also about that time that Florida moved from being a common law pleading state to having definite rules of procedure that you had to follow. So in some respects, a new lawyer was not too far behind those practicing, because everyone was working on new rules and learning new methods.
I know there's been a lot of celebrations that have either been held or being planned to celebrate the first 50 years of the Florida Bar. And so I wondered what your perspective would be about how the Florida Bar has changed in their first 50 years.
Well, I think that there's been a considerable improvement. The Florida Bar now has a great deal of emphasis on continuing legal education, which it did not when I started practicing law. The Florida Bar has improved its disciplinary procedures, its grievance mechanisms, and I think that over the years that the Florida Bar has done a good job and has been a very powerful influence on the legal profession. You have to recall that when I started practicing law, there were about 4,000 lawyers in Florida, and older lawyers were telling me and my parents how crowded the profession was. And tell you, son, it's really going to be tough. And today we have around 60,000 members of the Florida Bar, and about 50,000 of them practice here in Florida.
Well, jumping back to when you first started out, what aspects of your law practice did you find to be the most fulfilling?
Well, when I started practicing law, of course, as a young lawyer, you handled almost any type of case. These were the days of the general practitioner, and you might handle a criminal case or a divorce case or representing someone in a traffic court. Or you might be writing a real estate contract. Of course, it's so changed now, as you know, from the processes of specialization that have occurred. I really found most fulfilling what happened to me in some years after I started. In 1956, I was appointed Associate Municipal Judge for the city of Sarasota, and that was a big title. It paid $600 a year, and I had to hold court usually once or twice a month, and mainly I dealt with local traffic offenders. But after I was an Associate Municipal Judge for a few years, the City Commission appointed me to be City Attorney in 1959, and that was a very challenging job. I felt like I was young for the job, and I think I was the youngest one to hold the job. But it was a real pleasure, because I was always interested in government, and while I had some apprehensions about taking the job, I soon fit into it and found myself advising the commissioners and the city manager and the department heads and litigating cases in federal and state courts and appearing before the state Supreme Court. And I found that to be probably the most fulfilling part. It was a part-time job, and during that period of time my practice developed in the fields of probate, insurance, real estate, and to some extent civil litigation. But for many, many years, I was a city attorney for a little over 11 years, from 1959 to 1970. And there were so many challenges, because the years of the 60s were the years when we had all the civil rights issues. And those who were in control at the local level had the responsibility for bringing about a lot of changes, and a lot of past practices were discontinued, and lots of advancements were made in the treating of all persons equally. And this, of course, resulted in lots of controversies, but it was interesting to work on those programs.
And throughout all of this, you were also involved in the Judge Advocate Corps?
I was a reserve officer in the Judge Advocate General section of the U.S. Air Force, and I would train maybe 1 or 2 days a month, and then in the summer usually either go to school or go to serve on some base. A large part of my training, of course, was at MacDill Field, which was a little over an hour away from my home. And a lot of my work, particularly during the Vietnam, was working with casualty assistance problems and drafting wills, powers of attorney, and advising troops on some of the domestic relations problems that were rather common.
Well, you've had a lot of interesting things that you've been able to do with your law degree, been able to use it. What aspirations did you have as an attorney?
Well, interestingly, the aspirations that I had have largely been fulfilled. The first aspiration I had was I wanted to represent a public body, like a city or a county, and I had that opportunity. And the second aspiration I always had was I thought it would be very interesting and fulfilling to sit on an appellate court, and I was given that opportunity in November 1974, and as you know, I sat on the Second District Court of Appeal from January 75 through January 1992, and that was probably the most fulfilling position that I have ever experienced.
What are some of the significant changes that occurred in the law during your career?
Well, of course, during the 60s, vast changes occurred in the law in the United States. The United States Supreme Court decided numerous cases which affected the rights of criminal defendants. Some people call this the criminal law revolution of the 60s, and that's probably an apt description. Such cases are known by many people today as Miranda, Mapp, Gideon, Galt, and of course there were dozens and dozens more. What happened there was the U.S. Supreme Court, in effect, built a floor on procedural rights for criminal defendants. Effectively, the criminal procedure was nationalized to some extent by providing standards that state court as well as federal court judges would have to abide by. But related to the practice of law, there were a number of interesting developments. You know, when I started practicing law and you had a jury trial case, you had to dig through the Southern Reporters to find the type of instructions you wanted to ask the judge to give the jury. Today, of course, as you well know, we have more or less codified instructions for criminal cases and for civil cases. Also, things like the evidence code, where we found our evidence rules throughout the judicial decisions, and the evidence procedures and requirements became codified. The title standards were put into the law, and so you witnessed a sort of a structural process of codification of a lot of things in the development of the law. This made it more efficient to practice law, and of course enabled lawyers to do more for a client with less time, which became somewhat more economical for the client.
I know you've already touched on the subject of the 60s, but how do you see that changes in society and the law have affected the legal profession?
Well, the changes in the law, of course, have been very great. They are a reflection of society. The changes occurred because of the introduction of women into the workforce. the equality that was eventually given to persons of all races and backgrounds. And these things had to affect the practice of law. The fact, for example, in the criminal area, that under the Gideon case, that defendants who were charged with serious offenses had the right to have counsel, and the states and the local governments had to provide that counsel at public expense to those who were unable to pay. But there were so many regulations that have come about. You see, here in Florida, when I went to law school, we had about 2.5 to 3 million residents in the state. Today, we're probably pushing 15 million. And I've mentioned the number of lawyers. And the increase in lawyers has probably been more dramatic than the population, because as we've become very highly urbanized, more problems seem to have developed between people, and because people are more sensitive of their rights, and there's more emphasis on the rights of women, on the rights of consumers, on the rights of defendants, and the distribution of risks in society. And all of these things, of course, are grist for the mill of law practice, and they have caused many people to consult with lawyers who never would have consulted with lawyers many, many years ago. And they find it either essential or desirable to determine their rights based on the Constitution and the laws. And, you know, it's the lawyers who were able to channel change through the law. We had these changes in society, we needed changes in the law, and the lawyers were the ones best equipped to channel that change.
That brings us to the provision of legal services, equal access to the law. Has the legal profession become better, or has it regressed from the standpoint of public service?
That's a little difficult question. I suppose you could almost say the answer is yes, and the answer is no. Yes, I think it has become better in many respects. With the specialization that has occurred, a person who requires legal services can probably get those legal services from somebody who is far better qualified in a given area than they would have years ago. It has regressed in the sense that certain lack of civility seems to prevail among lawyers and among people generally. Some of the garish advertising that we have seen, I think, probably has something to do with this. I think the Florida Bar, however, is doing a good job of trying to regulate that consistent with First Amendment rights. The legal profession, I think, has always tried to furnish services to persons who cannot afford a lawyer, but that's become more formalized in the legal services organizations and in the pro bono work. I think that there's some very good pro bono efforts underway in the local bars. I think that's very commendable.
Do you feel that Florida bar members are effective in reaching beyond the profession to assist the public?
I think they are. I think that historically the legal profession has produced a lot of leaders in the community. There's hardly a non-profit organization that you come across that does not have a lawyer on the board of directors or in some type of decision-making position. And I know any of us who have been lawyers have probably written the bylaws for several non-profit organizations, and I think they've given a lot of assistance in that regard. Today, you don't have quite the same camaraderie in the legal profession that existed when I became a lawyer. One of the reasons, of course, is that communities are so much larger. It's I guess, a little easier to remain anonymous today than it was some years ago. I think we probably need more emphasis on public service in the legal profession.
How could this be improved?
It can be improved, I suppose, by encouragement, by liaison with other types of professional organizations. It can be improved considerably by the action of local bars. I've always regarded myself as being rather bar-oriented from the standpoint of the local bars. I've served as president of our local bar many years ago, and I think that the local bars can do a lot in this regard, and I think that there are other organizations that can assist. I think the American Inns of Court is a positive force.
Okay, and what do you feel the Florida Bar is doing to improve the profession?
I think the Florida Bar has been very proactive in the field of education, and through the modern means of technology, they have brought speakers and materials to lawyers in even the smallest communities by video tapes of seminars and by presentation of outstanding speakers who have great expertise in particular fields. I think the Florida Bar's efforts are very great from an educational standpoint, and also from the emphasis that the bar has placed on pro bono activities and on public service generally.
What recommendation would you like to share with the law schools initially as to new or different methods in law school training for new attorneys?
The law schools, as you probably know, went into the case method of studying law. This started in 1869 when Christopher Columbus Langdell became the dean of the Harvard Law School and brought in other professors who were all interested in the case method of studying law, which prior to that time was not a prevailing method. The case method was pretty much along the lines of what one professor said, that the law student examines the appellate decision much like the geologist examines a rock. And the case method became very, very popular, and it spread throughout all of the law schools over the succeeding years. Now, I personally think the case method is a good method for teaching law in the first year, and generally good for most of the second year courses. I believe, however, that law schools in the last year of education or training should focus more on the development of skills and on clinical type training. I think that with the decline in the individual mentoring that is available to new law graduates today, that it's very important for a law graduate to sort of be able to hit the ground running when he or she graduates from law school. I think that some law students, of course, would say, well, I don't intend to be a trial lawyer or trial advocate, and so I really don't need these skills. But I think to some extent, every law student needs them, because I think that a person who is going to become a lawyer should have a good understanding how lawyers perform. And I think also that the law schools need to emphasize the areas of negotiation and the various methods of alternate dispute resolution, because I believe that the negotiation, arbitration, mediation will be used more and more in the settlement of disputes.
The most recent Tort Reform Act created a private judging option where litigants can hire a judge or hire an attorney to play the part of a judge, hire jurors, and submit their case to a jury trial in front of this private judge, and then the result, I guess, is filed with the local circuit court, and it's appealable right up to the Second District Court of Appeal, just as if you'd had a civil jury trial. What are your thoughts about private judging?
I've had very little experience, actually no experience at all, in review of any cases where private judging has taken place. I know that there was considerable controversy about the subject in California, where I think it was first instituted. I know that some critics say that private judging just enables wealthy people to get their cases heard, and people of modest means who cannot afford that have to have their cases be delayed until the judge can get around to them. On the other hand, if individuals are willing to pay in order to get a quick resolve, that of course can relieve the court system of some of those cases and enable some of the people who may be of less means to have their cases progress. I don't know that I really have come to a conclusion on that. I think I'm just kind of beginning to understand the problem. I don't have any particular bias for it or against it at the present time. I think, though, that it's important to give it a try, and I think we should look forward to seeing what some of the results are and what the participants in those private trial judge resolution programs, what they think about it once it's over, and what those who are active in the program think about it. And I think that's very interesting. I certainly think that we need to try innovative procedures in order to see if we can improve the justice system, because the old adage about justice delayed is justice denied, of course, we've all heard, and that's very true. One of the criticisms that the average layperson has of the legal system is the slowness of the system to act.
How do you feel about the right to trial by jury? Some people feel that a lot of this tort reform is seeking to limit the access of people to jury trial. Do you feel that alternative dispute resolution, private judging, is a way of circumventing the right to trial by jury?
Not necessarily. I would start with the premise that I think the right to trial by jury is very important and is an essential part of our justice system. And I think that it should be preserved. Now, having said that, I see no problem with having certain screening panels and having certain measures taken which do not necessarily deprive a person of a jury trial, but make the dispute qualify as one to be tried by jury. You, as a trial judge, are intimately familiar with the procedures for summary judgment, which in the last half of the 20th century have become formalized and very important. Of course, as you well understand, that if there is a summary judgment to be entered, it deprives a person of a right to trial by jury, but it's not entered if there is any doubt or even the slightest suggestion of a doubt that an issue could be tried by jury. I think we have to remember, though, in that respect, the right to a trial really presupposes a genuine issue of fact to be tried by a jury. And where that exists, I think the right to the trial by jury should remain inviolate. I think, of course, it is so essential in the field of criminal law. I think if we were to dispose of the right to trial by jury, it would cause a great deterioration in the criminal justice system.
What can lawyers and judges do to make equal justice under the law a reality?
To make equal justice a reality under the law, first of all, would mean that every person should have access to someone who is trained in the law, who can advise them of their legal rights, and who can pursue those rights on their behalf. This means that it is essential that we have state-supplied counsel in criminal cases, which we do, and that it's essential that those who are too poor to be able to employ an attorney should have access to the legal system, because access to the law, of course, comes primarily through the courts, and unless you have someone trained to assert your rights, you generally are not going to be able to necessarily arrive at the correct decision. So I think that this can be done in a number of ways, one of which is through the pro bono efforts, and probably beyond that, there needs to be some type of arrangement where people who are of modest means, not people who are indigent, but certainly not wealthy, but people who are of modest means can find from a panel of lawyers someone to represent them. Now, I think the Florida Bar, over a period of years, has tried with the lawyer referral service, and I think from what I've seen, that has accomplished quite a bit.
Changing the subject now to mentoring, how would you feel if there were a formal mentoring program that was available to new attorneys?
When you say formal mentoring program, I'm not sure exactly what that would contemplate. I think that mentoring is important. I think mentoring can best be accomplished at a local level through local bar associations by providing lawyers who are agreeable to serve as mentors to, I started to say young lawyers, however, I think it's better to say new lawyers, because there are a number of people in law school today who are retraining, and they are not necessarily young lawyers. I recently had one student who was age 63, and I think that people who are new lawyers probably need to avail themselves of that. I am not at the point where I think it should be required.
How do you define ethics, and how does this differ from the way that you would define professionalism in the legal profession?
I think ethics, as I would define it, ethics deals with morality, of respecting other person's rights and performing your duties and obligations toward other people. We have refined ethics from a legal standpoint, and that's probably been necessary because we have to have some standard, some benchmark to measure ethical and unethical performance. So we have devised a large number of rules of ethics for lawyers, rules of ethics for judges. And I think it's important. However, I think they really set up pretty much of a standard baseline. Professionalism, on the other hand, I think is a more encompassing term. I think professionalism encompasses ethics, but to me the components of professionalism would be ethics, competency, and civility. And I think each is important. I think it's important for a lawyer or for a judge to be ethical, but it is also very important for each to be competent and to be civil. It's probably this last category to where we have fallen down more as the profession has expanded so rapidly in recent years, to where there is somewhat of a lack of civility that is evident among some lawyers. And perhaps this is because lawyers are not as close to one another. Bars have expanded very, very rapidly. And any time any business or profession expands very rapidly, the people in it are not necessarily integrated into the customs. I think that law schools need to emphasize civility.
Surely you've only heard about this problem. I can't imagine anybody appearing in front of you as a senior judge and not being civil. Have you experienced a lack of civility at the appellate court level?
Very little, very little. I think from my conversations with trial judges such as yourself that they sometimes do experience a lack of civility, particularly in some of the domestic relations type cases. And I understand that many of these cases today are handled by non-lawyers, that is on what we call a pro se basis, either on one or both sides. And of course, these people are not trained in the requirements and the respect that's due the judge. But at the appellate level, for one thing, the lawyer is facing three judges, often many years older and more experienced, and I think a lawyer would be less prone to step out of line or to be uncivil than perhaps a lawyer would be in a one-on-one relationship between herself or himself and a circuit judge. It's very difficult for me to imagine a lack of civility before a circuit judge because I went to the appellate court directly from the law practice, and I practiced before numerous circuit judges, and I cannot believe that I would have intentionally done anything that I would regard as not being civil.
I know that you've personally undertaken to raise the level of civility with the legal community by your involvement with the American Inns of Court movement. Can you tell us a little bit about the American Inns of Court movement and how it affects professionalism?
Well, the American Inns of Court movement really became established in this country after Chief Justice Burger, or late Chief Justice of the U.S. Supreme Court, visited some of the legal institutions in England and became impressed with the competency and civility in the advocacy in the English courts. It was brought to America. It has expanded very rapidly, and every community of lawyers practically now has an Inn of Court. An Inn of Court is a group of lawyers and judges classified as masters and barristers and associates and pupils depending upon their position in the law. And these Inn of Courts have meetings which are pretty much role-playing type meetings. Instead of listening to a speaker, members of the Inn of Court actually involve themselves in different types of programs. Some of them do emphasize professionalism. Others may emphasize jury arguments or cross-examination of witnesses or presentation of certain types of technical evidence. But there's more than just the demonstration programs. If you're a member of the Inn of Court, it pretty much carries out the old English saying of we meet as adversaries, but we eat as friends. And the members of the Inn of Court meet once a month usually, and they sit at tables in their own group. Their groups are usually known as pupillage groups and usually consist of 8 or 10 lawyers and judges. And it gives the lawyers and judges an opportunity to meet together ethically, professionally, but on a social basis to where problems can be discussed and solutions arrived at. I think the American Inns of Court probably is one of the more positive programs in the American bar today.
And I think it'll come as no surprise to our listeners that you've been honored by having a chapter named after you. Isn't that not correct?
That is correct. I was instrumental in organizing the Inn of Court in Polk County while I sat on the 2nd District Court of Appeal, and upon retirement organizing the chapter first known as the Sarasota County American Inn of Court, and later was renamed in my honor, for which I was very grateful.
If you knew that your advice would be followed, what advice can you give to those who are currently in the legal profession?
I suppose the advice that I would give is pretty much the time-honored advice that older lawyers and judges have given to younger and newer lawyers over the years. I think the first thing you would advise is that your integrity is your greatest asset. Never lose it, never tarnish it. If you have a problem of ethics or professionalism that you cannot resolve in your own mind, that you should try to take it to someone more experienced and get counsel. I think that I would advise that most deficiencies in performances by lawyers does not come from a lack of knowledge or a lack of ability. It comes from a lack of preparation. And carelessness and lack of preparation are those things that we need to avoid. It's very easy to fall into the line of least resistance and not thoroughly researching the positions that you're going to advocate before a court, or not thoroughly studying the law applicable to a transaction that you're going to handle. But these are the things that we must discipline ourselves to do if we're going to be effective lawyers, and we need to keep current. I also think that a lawyer today who will probably practice in a very specialized area needs to very carefully develop a network of lawyers to make referrals to, because I think it's very important today. A person goes to a lawyer and the lawyer doesn't handle personal injury cases or domestic relations cases, but yet a person counts on that lawyer, much as I count on my primary care physician to refer me to a physician in the proper specialty. And I think that's an important thing that sometimes lawyers have overlooked.
How important do you feel it is for attorneys to be involved in local bar associations or national bar associations?
I feel it is vitally important. I think that much is gained by association when lawyers and judges can sit down among themselves and discuss matters for the betterment of the profession. I think the organized bar nationally, state, and locally are very, very positive instruments to keep us all in line and to help us resolve problems, and also to extend help in the communities where help is needed, not only from a legal standpoint, but often from the standpoint of just some type of community or charitable service. And these are the things that put a positive face, a good face on the legal profession. You know, the legal profession gets a lot of, they take a lot of abuses. Some are probably justified, others probably are not. I suppose as a profession, the legal profession probably rivals used car dealers and mothers-in-law as far as being those who are subject to criticism. So since we are in an adversary system, and since in court cases usually one person wins, or one side wins, and the other side loses, oftentimes I used to hear said when I practiced law that you're fortunate if you even had survivors, because the system, some people felt sort of abused them. But I think it's very important that lawyers belong to their associations. I was very instrumental on the Florida Court Educational Conference in developing programs for judges and making the Court of Appeal Conference one where we actually had educational conferences that didn't used to exist.
How can we as trial judges instill confidence in the litigants who appear in front of us so that they understand how the system works, and they understand that the system is dealing with them fairly. Many times litigants will think that they lost the case because their lawyer plays golf with the judge, or they lost their case for some other totally irrational reason. How can we instill confidence in litigants so that they will understand the legal system and enhance the professional reputation of the courts?
That's a question you could probably answer better than myself, since you are a well-known and very fine trial judge. I have not been a trial judge, although I have on a few occasions sat as a trial judge while I was on the District Court of Appeal. I think one of the things that trial judges get criticized for is that it takes some of them so long to make a decision. And again, we get into the old adage about justice being delayed. I think a trial judge must be prompt and must try to dispatch his or her court business with great facility. I think that a trial judge, by his or her demeanor in court, means very, very much. Let's face it, the people are judging the legal system primarily by what trial judges do, not necessarily by what appellate judges do. Appellate judges like myself have a very low profile, and most people in the district couldn't even name their appellate judges. Most people in a locality do know who the trial judges are. Another way, I think, is by the trial judge himself or herself conducting his or her life in a commendable way and not given to excesses, which occasionally we see. By the trial judge treating persons very fairly. And I think for the most part this occurs, and we all have our own personal little biases, but certainly a trial judge has to be a champion at treating people equally, irrespective of that person's sex or race or religious or ethnic background, or even where that person might be of a character that you would like to maybe disdain, but you have to be very careful about it. People are very sensitive. They look upon those of you who are trial judges as being very important figures in the system of justice.
Who were your role models in the legal profession?
Well, I suppose the greatest role model I have had was a man with whom I entered practice a couple years after I got out of law school. He, like I, was a recent graduate, and we decided to throw our fortunes together, and we practiced together for over 20 years before I went on the bench. His name is John Wood, Mr. Wood, who was a member of the Board of Governors of the Florida Bar for many years, and who is probably one of the most ethical, professional persons I've ever met in the legal profession. And I think he, being a little older than myself, probably gave me very good counsel.
To what extent have you achieved your aspirations in the practice of law?
Well, that's pretty simple. I started out in our interview telling you that I originally wanted to be a public attorney because I like representing the public, and I certainly achieved that in my 11 plus years as a city attorney. I also wanted to be an appellate judge or in some type of capacity in the appellate courts, and I achieved that, of course, by being on the District Court of Appeal for 17 plus years and serving as its chief judge at one time. And finally, I thought that as I have grown older, which I obviously have, that it would be very great to be able to impart what you have learned to some of the younger and newer students of the law who are coming along. And shortly after I retired, I was asked to be an adjunct professor, and I taught criminal law 1 year at the Stetson University College of Law, and then I was promoted to be a professorial lecturer, and since that time I have taught appellate practice every year. I think that through being city attorney, appellate judge, and a law lecturer, that I have probably achieved that. And I also like to write, and I have been able to co-author some texts on law, and that's been fulfilling.
What core beliefs have helped shape your life?
I suppose I have a core belief in God. I come from a strong religious family background. I have a strong belief in my wife, who has also been my best friend and who has always urged me to strive for excellence in the things we do. I think if you epitomized it, you could go to this song that was very popular in recent years, and I could say that she has been the wind beneath my wings. And I have children. I have a son who's a professor and a son who's a lawyer. They've always been very supportive of me, and I think these and our core beliefs in God and family and in our United States, I think these are the core beliefs that have sustained me.
For what would you like to be remembered?
I suppose that I would like to be remembered as being a lawyer and a judge who worked hard and who tried to be conscientious and considerate of others and tried to prepare my work well and effectively represent my clients as a lawyer and impartially discharge my duties as an appellate judge, and perhaps for some of the hundreds of opinions that I have written, which may give a little guidance to some on the trial courts.
How can we help young law students keep their ideals? A lot of us in my generation regret the fact that so many law students graduate with such a huge debt that they're under enormous pressures to find that first job and start paying off their law school indebtedness. How can we help them maintain the newness, the shininess, the idealism that really, if you don't have that, you don't have that love of law, it's not going to be the rewarding experience that you've had?
It's very difficult, I realize, because when the emphasis on repaying what money has been loaned to you so that you could attain your degree in law, that there is a great press on you to tend to be materialistic, and it's very difficult to talk to someone who is under the burden of making large payments to repay debt incurred, to say you should go out and help others and to do this without any fees to yourself. And I'm not sure. We need to try to encourage these people. I suppose we could remind them of the great opportunity they had to gain their law degree, but I'm really not sure that I have a good answer. I would think that probably those who are somewhat younger than myself might be able to answer that more effectively than I can.
Is there anything else you'd like to share with our listeners about professionalism and your walk through your career in the law?
No, I found the law to be interesting, challenging. I have a love of the law. I have a great respect for the institutions of our country, both civilian and military, and I've served in each. I have great admiration for those people who serve, particularly those people who serve at a local level in governmental positions, but oftentimes they receive very little compensation and considerable criticism. But I'm a firm believer that local self-government is the best foundation for a democratic republic that we have. And I certainly appreciate their service, just as I appreciate persons who are willing oftentimes to give up a very good remunerative career in the law practice to serve in the judiciary.
Well, with that, we have come to a close. Thank you so much.
Thank you very much, Judge Isom. I've enjoyed being with you.
I've enjoyed our conversation. It's been wonderful. Thank you.